Now we will discuss about what is will. Section 2H of the Indian Succession Act 1925 defines will, and it is defined as a legal declaration of the intention of a testator with respect to his property, which he desires to be carried into effect after his death. So, the wills are governed by one of the oldest law called the Indian Succession Act 1925. This act is applicable only over Hindu and no other religion. The worth mentioning case law in this regard is Sanjeev Janeja versus State and others, which summarizes both sections 2H and 59 of Indian Succession Act 1925 governs the capability of person to make a will. I request you to go through this case law in your free time. When we talk about wills, the term codicil also comes. Let us see what is the difference between both of them further. Will versus codicil. Will is a legal document that outlines a person's wishes regarding the distribution of their assets and the appointment of an executor to carry out those wishes after their death. The term executor is further defined in another slides. All aspects of estate planning and can be used to specify the distribution of property, appointment of guardians for minor children, and other matters. And also, a will can be modified or revoked at any time during the testator's lifetime, whereas codicil is defined as a legal document used to make changes or additions to an existing will. It is used when a person wants to amend certain provisions of their will without completely rewriting the entire document. A codicil must be executed with the same formalities as a will and is subject to the same legal requirements. And it is a separate document that is attached to the original will and becomes a part of it. Let us talk about now what are the options to devolve. So there are two options to devolve. First is testamentary succession, where any person governed under the act leaves behind any will or codicil which instructs the executor how the property has to be used or who have rights over that property. This is testamentary succession. The second one is intestate succession. A person is said to have died intestate when he dies without making any testamentary disposition concerning any of his properties. This is intestate succession. As I promised you earlier that I will discuss about executor, now let us discuss about executor. An executor is an individual appointed by the testator to carry out the provisions and wishes stated in the will after their death. The executor acts as a representative and has the responsibility to manage and distribute the assets and property according to the instruction outlined in the will. They are entrusted with the task of administrating the estate, settling debts, paying taxes, and distributing the assets to the beneficiaries as per the testator's intentions. The executor's role is important in ensuring the smooth execution of the testator's state and fulfilling their final wishes. Next topic to be covered are conditions for making valid will. Section 63 of the Indian Succession Act 1925 outlines the conditions for a valid will. Following are the summary of conditions listed out below from the said section. The testator should sign or affix his mark, for example, thumb mark. The will must be attested by two or more witnesses. The witnesses must have seen the testator sign or affix his mark to the will. Each witness shall sign the will in the presence of the testator, and the witness should not be a beneficiary under the will. Now let us see what are the order of preference of legatees. But before that, we will see who are the legatees. Now we will discuss who are legatees and what are their rights. A legatee refers to a person who is named in the will to receive a specific gift, property, or asset from the testator. It is also defined as a beneficiary designated by the testator to inherit a particular item or portion of the estate as outlined in the will. The legatee has the legal right to receive the specified gift or property upon the death of the testator, subject to any conditions or provisions mentioned in the will. The testator has the discretion to name one or more legatees in their will, and the legatees are entitled to their respective legacies according to the distribution plan specified in the will. Now, the general preferences of distribution. First, spouse, then children, then parents, then siblings, then other relatives and friends. And testator has also taken these decisions towards charity. Now let us see what are the various types of wills. Following are the types of wills. First is conditional, which we also call as contingent. A conditional will specifies that certain conditions must be met for the distribution of assets or implementation of the will's provisions. If the condition fails, the will is inoperative and void thereafter. Second one is a joint will. A joint will is created by two or more individuals who make a collective statement of their wishes regarding the distribution of their assets after their deaths. Third one is a mutual will. A mutual will is a type of will created by two individuals, usually spouses or partners, to leave their assets to each other with a common plan for the final distribution of their assets after both of their deaths. Fourth one is concurrent wills. Concurrent wills are written by one person wherein two or more wills provide instructions for disposal of property for the sake of convenience. Next is unprivileged wills. Unprivileged will. Any person who is not eligible to create a privileged will can create an unprivileged will. It is the most common type of will in India. Next point is privileged will. This type of will is created by members of the armed forces, including soldiers, sailors, or airmen, while they are on active duty or during a voyage. Worth mentioning case law is Sunita Sivdasani versus Geeta Gadwani. I request you to go through this case law. Next one is sham wills. Sham wills are executed but held invalid if the testator does not intend to execute as per his or her wishes. It is because, as per the Indian Succession Act, a will made by fraud or coercion or by taking away the free agency of the testator is considered invalid. Last one is holograph. The testator writes the holograph wills entirely in its own handwriting. Let us talk about few highlights. A Hindu could not by will dispose of his entire property so as to defeat the claim of his wife and of other persons who are legally entitled to maintenance from him. Worth mentioning case law in this regard is Pramodhanath versus Nagendra Bala. All schools of Hindu law have consistently agreed that the power to make wills extends to the separate or self-acquired property of the testator. In regard to co-partnership property, the power to make wills differ according to different schools of Hindu law, which are as follows. The Daya Bhaga school. The Daya Bhaga school recognized the right of co-partner to dispose of his interest in the joint family property by will. The Mitakshara school. The Mitakshara school, however, no co-partner could dispose of his undivided interest by will, even if other co-partners consented to such disposition. However, today, under Section 30 of the Hindu Succession Act, a Hindu may dispose of by will or other testamentary disposition, even his interest in a coparcenary property. A Hindu female could dispose of her Stridhan property by will, except when the Stridhan was non Sadaika, in which case the consent of the husband was required to validate the will. However, now under section 14 of the Hindu Succession Act, any property possessed by a female Hindu, whether acquired before or after the commencement of the act, becomes her absolute property, and she becomes the absolute owner of such property and is therefore entitled to dispose of such property by will. A sole surviving copartner could dispose of his property by will, but such disposition would be inoperative against a subsequently born or adopted son. This rule was true in regard to copartnery property, but a Hindu adopting a son could make a will in regard to his separate property, and the adopted son could not challenge that right. Good case law in this regard is Sri Raj Venkat Surya versus Court of Wards. I request you to go through this case law. Let us see the summary now. So these are the summaries. A will is regarded as the expression of the testator's wishes regarding the utilization of their property after their demise. Second point is the safeguarding of such wills is crucial, and proper registration plays a significant role in validating them. Thirdly, it is important to note that an individual cannot bequeath ancestral property through a will. However, they can create a will solely for their self-acquired property. A will does not entail any immediate transfer or impact on transfers made during one's lifetime, but it serves as a declaration of intent to designate a person who will manage the properties after the testator's death. And a will governs the process of succession and establishes the testator's stated preferences for the distribution of assets. Thank you everyone for watching my presentation. I wish you a good day.